Court. The Supreme Court was not set up in our Constitution as the superior branch of the federal government. And then there's no need for me to, well, Madison says in his report on the Virginia resolutions that it is a plain principle founded in common sense that the states, as the sovereign parties to the Constitution, are the final authority on whether the federal government has violated the Constitution, and that the states may check all three branches of the federal government, not just, they may check the judiciary, the executive, and the legislative branches by nullifying their acts. If the judicial branch connives with other branches in usurping powers, our Constitution will be destroyed if we do not stop them. This is what James Madison said in his notes on nullification, in his report on the Virginia resolution. I'm sorry I didn't have time to finish. I hope that during questions someone will ask me about the so-called nullification crisis.
Hi Glenn, how are you doing tonight?
I'm doing well. How are you doing? That was a really good video you guys were playing. I was enjoying that completely.
Yeah, that's a TikTok video that speaking on what everybody needs to know. And are you on TikTok? We can forward it to you, or do you want to play it?
No, I don't have a TikTok profile. I'm kind of disappointed that it's on TikTok because it's the communist Chinese, and YouTube, I'll tell you, they've had a coming to Jesus moment, I think, since Trump took office. Or there's other profiles or other what do they call it, websites that can host, videos like that. But I'm not on TikTok, and I'm not interested in being on TikTok because it's the communist Chinese.
Well, Glenn, I'm happy to record that in Telegram, and then you can just watch it right in Telegram, and I can post it somewhere.
Yeah, sure. Yeah, I wouldn't mind downloading it and putting it on my channel. It's brilliant. Yeah. Anyways, yeah. So, what? I know last week we talked about that notice of void judgment, and I made a bunch of changes to it, but I got it filed, and now they're sending me a certified copy. But I don't know. I made a bunch of changes to it. Right now, I'm preparing a letter to the FBI special agent in charge of the Dallas field office. So I was thinking maybe we can go through that. Although we could go through that notice of void judgment, but I noticed that I had uploaded it last week, and so I guess we talked about it last week.
So why did you feel a need to? You said you were going to be modifying a bit, but you changed it before you sent it in, and then it was accepted now? Is that?
Well, it's they don't have any choice. They can't turn something away.
Okay, good.
They can unfile something, but they haven't done that, and it's quite in your face. But it's the truth. They can't dispute that. In fact, what I'm doing is I'm going to attach it to this FBI special agent in charge. And I'm sending a copy to the Attorney General and to Donald Trump, and I want to bring some heat down on these bought and paid for whores. Anyways, so we'll talk about that in this letter to the FBI special agent in charge of the Vatican's Federal Bureau of Investigation.
Nice. Yes, that would be great. So do you want me to start recording and get the bells and do the prayer and everything?
Yeah, absolutely, yeah.
The recording has already started, Lee.
Thank you.
Yeah, my YouTube video's already started too. When I saw that lady up there, I went ahead live on YouTube. So it's live on YouTube.
Perfect. Okay, here we go. I'm going to read this 3 times. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in appropriate manner to eliminate all conflict and false allegations. Is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency, federal, state, county, city, township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, state your name, and state your position. Say your name and state your position. Sorry. Okay, number 2, this meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forum is forbidden and shall be addressed in an appropriate manner to eliminate all conflict and false allegations. Is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, city, or township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, state your name, and state your position. Okay, and one last time. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, city, or township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, state your name, say your name, and state your position. And in closing, we will say a short prayer. Oh, Holy Father, please bless our meeting with eyes to see and ears to hear the messages and information being presented with an open and caring and compassionate heart for our fellow brothers and sisters. Let it be done. Take it away, Glenn.
Yes, let it be done. The reason I'm a little bit late is I was on a Zoom call where there was someone sharing some ideas that are ways of doing things similar to exceedingly, and and there's some pretty interesting stuff out there, let me tell you. Anyways, so what we'll do is we're going to talk about. I was just trying to get this as big as possible so people can see it. And I don't know, can you guys read that?
Yes, and all anybody has to do on Telegram is click on it and it will enlarge itself.
Oh, okay. I didn't know that. anyways, this is a notice and demand that I'm preparing, and I'm just about done. I've really done a lot of tweaking, and I wanted to attach my affidavit of life and my 12 presumptions, mandatory judicial notice of 12 presumptions, and this FBI special agent in charge notice and demand. I was going to attach those 3 documents. Oh, and the notice of void judgment. I was going to attach them certified copies to these 3 documents and send them. There is one going to the actual special agent in charge. Notice it's special agent in charge, Dallas, the Vatican's Federal Bureau of Investigation, and it's going to Pamela Bondi, Private Wilbing, acting as the Vatican's attorney with the rank of general, United States Department of Justice, and Nancy Larson, Private Wilbing, acting as the Vatican's acting United States attorney, Northern District of Texas. They're all the Vaticans, and we'll go through this and explain why. Anyways, so this is a standard notice and demand that I do. It's quite lengthy. It's 33 pages. But I think I've pretty well, if there's changes, they'll be like minor changes from before I send it out. I went and got the notice of void judgment. It's been filed. I confirmed with the clerk today, and I told him I was going to order a certified copy, and I expect to have that probably Monday or Tuesday. So, anyways, so
why couldn't you get it right then? Why couldn't you just pick up a copy out of the file right there?
well, I've been avoiding the federal court because I don't have federal ID, and now I know that there's been other federal courts that I tried to go to. Like there was one in Plano, which is the Eastern District of Texas, and this was probably about 3 or 4 years ago when a friend of mine was in their hotel over there, and I was filing a petition for writ of habeas corpus, and I showed them a Republic of Texas diplomatic identification card. They wouldn't let me in. And the U.S. attorney came down and talked to me, and they were very nice, but they said you can't come in. So anyways, it's not federal ID, and I don't have federal ID. And so now the court that I go to in Dallas or in Fort Worth, they have not required it in the past, but they did come out recently and say that there's a big announcement. Unless you had real ID, you can't get into any federal building. And so I really haven't gone down there. I haven't pushed it. I haven't tried. And I just call them up, and it works just fine. And so that's the way I've been doing it. Call them up and tell them what I want, and the thing about federal ID is it's a two-edged sword. It tells them that they have jurisdiction. If you don't have federal ID, then they don't have jurisdiction, and that's useful. That's useful. Anyways, so we'll go through these point for point. This is a standard notice and demand, but I've made a bunch of changes throughout it because of the topic. Let me put it that way. So anyways, I, me, Meyer, myself, a man, a living soul, a sovereign inhabitant of the land of Texas and holder of the office of the people without the Vatican's owned and operated United States, Inc., do hereby notice you of the following. And every paragraph is going to start off with you, Joseph Rothrock, the private man acting as special agent in charge, Dallas Field Office of the Vatican's Federal Bureau of Investigation, Military Police, and subordinates and successors. And every paragraph is going to be the same way. So I won't read that. I won't belabor it by reading it over again because there's 33 pages to cover here, and so they all say the same thing. Are noticed that I accept your oath of office. And then are noticed as implied in your oath that equality under the law is paramount and mandatory by law. Are noticed as implied in your oath that if you think or assume you're representing me, the air of God, you're fired. Are noticed as implied in your oath that neither you nor any other man or woman or any person is competent in dealing with my affairs, with any of my affairs. And I put this, notice there's a footer here. And I put, what I do is I'll get a red pen and I'll draw a line to the margin, to the edge of the page from this copy claim, and I'll put my initials there and I'll write seal up at the top. And that's my seal, is red ink initials. Anyways, and every page will have that. You, Joseph Rothrock, are noticed as implied in your oaths that I'm competent for dealing in all of my affairs. Are noticed that any communication with me by you, your successors, or your subordinates shall be signed under penalty of perjury. They never do that. Are noticed that the Vatican's owned and operated Sestake Trust Minor Estate, 31 CFR 363.6, names GlennWinningham Fern in all block letters, Glenn W. Fern, and Fern GlennWinningham, or any derivative thereof, are common law copyrighted by me. You're noticed that any violation of my copyright or making a legal determination for me, representing me, or communicating with me in any matter not under penalty of perjury would constitute an acceptance to the fee of 1,000 1 troy ounce pieces of pure silver minimum, or no, 10,000 1 troy ounce pieces of pure silver minimum, or 1,000,000 1 troy ounce pieces of pure silver if violated for the purpose of profit or gain, and it's always for the purpose of profit or gain. 10,000,000 1 troy ounce pieces of pure silver if violated for the purpose of profit or gain more than 3 times within a year for each and every violation. And so with this little fee schedule I have here, it's easy to get it up into hundreds of millions of dollars, I'm telling you. Anyways, are noticed that if you make a legal determination for me, you're practicing law without a license. Are noticed that any violation as described in paragraph 8 above would constitute an agreement that I can seek relief from you, all of your corporate officers and directors, as well as your parent corporations and its officers and directors, jointly, severally, and personally. Our notice is implied in your oaths that pursuant to your Code of Law for the District of Columbia, now known as Title 18, United States Code 1342, my proper name is GlennWinningham, House of Fern, and my proper postal address is zip coded General Post Office, zip code exempt, care of 6340 Lake Worth Boulevard, number 437, Fort Worth, Texas. Non-domestic mail without the Vatican's United States Inc. And then it's referencing 18 U.S.C. 1342 and the domestic mail manual, which talks about proper mailing addresses. And if it is not shown exactly like this in any communication with me, it's further agreed by you, your subordinates, and your successors that you intend to be guilty of mail fraud. I've massaged the wording on that for a long time, and I like the wording on that. Anyways, our notice is implied in your oaths that any communication with the Vatican Sestake Trust / Minor Estate, 31 CFR 363.6, GlennWinningham Fern in all block capital letters, Glenn W. Fern or Fern GlennWinningham or any derivative thereof, in addition to the copyright violations, it is treason, breach of trust, sedition, perjury of oath, and other felony offenses because they're criminally converting my name for the specific purpose of violating my God-given rights for their Vatican handlers, because a trust has no rights and is a thing which is property under the Commerce Clause, Article 1, Section 8, Clause 3. And this is capitis diminutio, meaning the diminishing of status through the use of capitalization. In Roman law, diminishing or abridgment of personality, a loss or curtailment of man's status or aggregate of legal attributes or qualifications. Capitis diminutio maxima, meaning the maximum loss of status through the use of capitalization. John Doe or Doe John, the highest, most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. It swept away with it all rights of citizenship and family rights. And that's Black's Law Dictionary, 4th edition. Because as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union, and that's quoted in National Mutual Insurance Company versus the Tidewater Transfer Company, U.S. Supreme Court, 1948. Did somebody have something they wanted to say there? Okay, I guess
I
not.
think the mic just opened up, so go ahead. Sorry about that.
I think the mic was on, but like if you could post this now so I could please follow along, it'd be
But you want me to upload it?
Follow along with. Please, yes, thank you.
I'll upload it.
Thank you very, very much.
Let's see here. Oh, hold it now. Okay, it's uploaded.
Thank you.
Which is a plenary jurisdiction under the Pope's canon or Roman law. Plenary, a court's full and absolute power over the subject matter and the parties in the case. Black's Law Dictionary, 8th edition. Plenary, full, complete, entire. Black's 9th. Plenary power, complete power over a particular area with no limitations. This term is often used to describe the power of the commerce power of Congress. Under the Commerce Clause, Article 1, Section 8, Clause 3, Congress is granted full power over interstate commerce. The court has found that states are not able to pass laws affecting interstate commerce without the permission of Congress. Actually, I think I'm going to add something into that. Yeah. There we go. Okay, in the courts of admiralty and in the English ecclesiastical courts. So that's where it ties in the Roman law. Plenary power or plenary authority is complete and absolute power to take action on a particular occasion with no limitations. It's derived from the Latin term plenus, which again is Roman. Okay, to call it a contract with the objective of denying me my common law rights. There's no common law offenses against the United States, only those acts which Congress has forbidden with penalties for disobedience of its command are crimes. And that's, there's all sorts of sites there. You are noticed as implied in your oaths that all living souls that are inhabiting the land known as Texas are all American nationals, because at common law, anyone who's on the land has all the rights protected by common law, and they have more rights than one of the Vatican's 14th Amendment U.S. citizens / minor estates, 31 CFR 363.6. You're noticed as implied under your oath that the words person and whoever are only used for corporations and fictitious entities under the maxim for statutes of adjustum generis, because the word include is limiting. An individual is only the Vatican's minor estate, fictitious entities. Okay, and this is Title 1, Section 1. The words person and whoever include corporations, companies, associations, firms, partnerships, societies, joint stock companies, as well as individuals. Okay, so What I'm saying there is that include is limiting, number one, and they're listing fictitious entities here, which means an individual is also a fictitious entity. You're noticed as implied in your oath that because of the maxim of law justum generis, in the definition section of statutes, the entities listed are all the same kinds of entities. Adjustum generis of the same kind, class, or nature. In the construction of laws, wills, and other instruments, the adjustum generis rule is that where general words follow an enumeration of persons or things by words of a particular and specific meaning, such general words are not to be construed in their widest extent, but are to be held as applying only to persons or things of the same general kind or class as those specifically mentioned. For example, if a law refers to automobiles, trucks, tractors, motorcycles, and other motor-powered vehicles, vehicles would not include airplanes, since the list was of land-based transportation. Then it goes on. A canon of construction that when a general word or phrase lists of specifics, the general word or phrase will be interpreted to include only the types of same type as those listed. For example, the phrase horses, cattle, sheep, pigs, goats, or any other farm animal, the general language, any other farm manual, despite its seeming breadth, would probably be held to include only four-legged hoofed mammals typically found on farms, thus would exclude chickens. And that's Black's Law Dictionary, 8th edition. Your notice is implied in your oath that in statute writing, the maxim of law says the word includes means only that which comes after it and excludes all else by its use. Inclusio unis exclusio alterius, the inclusion of one is the exclusion of another. That's Bouvier's Maxim of Law, 1856 edition. And it goes on, a canon of construction holding that to express or include one thing and implies the exclusion of the other, or the alternative, for example, the rule that each citizen is entitled to vote implies that non-citizens are not entitled to vote. And that's Black's 8. Your notice is implied in your oath that in statute writing the word includes is a word of limitation. Include is a participial form thereof, is defined to comprise within, to hold, to contain, enclose, comprise, comprehend, embrace, involve. Latin include, to confine within, hold as an enclosure, take in, attain, shut up, contain, enclose, comprise, comprehend, embrace, involve. And that's Black's Law Dictionary, 6th edition. And this other one is the Montello versus Salt. Maybe I'll just do this. Yeah. Your notice is implied under your oath that it's a felony for whoever to claim to be a minor estate / U.S. citizen when it is known that they are not. And even though I can prove I'm not a whoever, I do not bear false witness. Therefore, I cannot claim to be a minor estate / U.S. citizen when I know that I'm not. And for anyone else to claim that I'm a minor estate / U.S. citizen, 31 CFR 363.6 is also felony false personation. And this is 18 U.S.C. 911. Whoever falsely and willfully represents himself to be a citizen of the United States shall be fined under this title or imprisoned not more than 3 years or both. And so for someone to accuse me of being a U.S. citizen is also false personation. Your notice is implied in your oath that a minor estate U.S. citizen is a person. 14th Amendment, all persons born or naturalized in the United States subject to the jurisdiction thereof are citizens of the United States. You'll notice that a U.S. citizen is a fiction of law. It might be correctly said that there is no such thing as a citizen of the United States. A citizen of any one of the states of the Union is held to be and called a citizen of the United States, although technically and abstractly there is no such thing. And then in their codes, definitions as used in this section, the term United States business means a United States citizen. So that's a company. And that's found at 102 Stat 1344, Public Law 100-418, August 23rd, 1988. And fictions of law were invented by the Roman praetors under canon Roman law for the Pope's ecclesiastical city-states, that is now the Vatican, under the pretense of doing equity. And this is Bouvier's Law Dictionary, 1856 edition, so this is all quoted from this quote here. and fictions of law owe their origins to the legislative usurpations of the bench, which means the fake judge is a legislator when dealing with fictions of law, which means the fake judge's legislative act is a bill of attainder, because a bill of attainder is a legislative act that applied to named individuals to inflict punishment on them without a judicial trial. And that's U.S. Supreme Court, U.S. versus Brown. Bill of attainder means a legislative act, no matter what their form, that apply to either named individuals or to easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. And so it goes into it more. And then Bill of Pains and Penalties. A Bill of attainder is actually death penalty. Bill of Pains and Penalties is less than a death penalty, because judges only hold office during good behavior. Article 3, Section 1. Judges in bad behavior engage in fraud upon the court. And you'll notice that your attorneys are all private bar guild members, because bar is an acronym and stands for British Accredited Regency. Regency, the office or jurisdiction of a region or body of regents, a government or authority by regents. Regent, a person who exercises the ruling power in a kingdom during the minority, absence, or over disability of the sovereign. Because all private bar guild members are appointed by the Inns of Court. Inns of Court, certain private unincorporated associations in the nature of collegiate houses located in London, and vested with the exclusive privilege of calling men to the bar. Black's Law Dictionary, 5th edition, which is located in the Pope's owned and operated dependent city-state, the City of London, called the Kingdoms of England and Ireland, now known as the United Kingdom and the Crown, since the concessions of England to the Pope, 1213. And this is, we will establish a perpetual obligation and concession that from the proper and special revenues or aforesaid kingdoms for all the service and customs which we ought to render for them, saving in all things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael 500 marks, and at Easter 500 marks, 700 for the Kingdom of England, 300 for the Kingdom of Ireland. Look it up, Concessions of England to the Pope, 1213. Because King John gave the kingdoms of England and Ireland to the Pope and agreed to rent them back for 1,000 marks sterling per year. And this is not long after this, by general excommunication of the king and people for several years, because he would not suffer an archbishop to be imposed upon them, King John was reduced to such straits that he surrendered his kingdoms to Pope Innocent III to receive them again and hold them of him under the rent of 1,000 marks. And that's Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of Pope, which means all private bar guild members are foreign agents of the Vatican and priests of Baal, which is why they're here under the Vatican Civil Laws of Congress, Foundation of Federal Bar Association, and Code of Law for the District of Columbia, now known as Title 35, USC 70501 through 70512. Claiming immunity under the International Organization Immunity Act of 1945 at 59 Stat 669. You'll notice that the Pope's owned and operated dependent city-state in the City of London, called the Crown, created the Sesticave Act of 1666. Yet still it was difficult to set bounds to ecclesiastical ingenuity. That's the Roman cult, folks. For when they were driven out of all their former holes, they devised a new method of conveyance by which lands were granted not to themselves directly, but to nominal fiefs, to the use of the religious houses, thus distinguishing between the possession and the use, and the receiving the actual profits. While the season of the land remained in the nominal fief, it was held by the courts of equity, then under the direction of the clergy. That's the Roman cult, folks. Isn't that convenient, eh? The Roman cult gets to decide what the law says. To be bound in conscience to account to assesticate use for the rents and emoluments of the estate. That's taxes, folks. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And that's Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. which is what precipitated the War of Independence, as evidenced by the causes and necessities for taking up arms issued by the Continental Congress in 1775. Statutes have been passed extending courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, and instead thereof to publish and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charter. We saw the misery to which such despotism would reduce us. That's dictatorship, folks. Gee, that sounds like a plenary jurisdiction from Roman law. Don't get me going. You're going to get me going now. And the organic law of the Declaration of Independence shows it was listed as reasons for the Declaration of Independence from the Pope's owned and operated tyrant, the Crown of England. And so this is only some of the grievances. There's actually a lot of them that talk about or allude to this. He's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation, for transporting us beyond seas to be tried for pretended offenses. Gee, that sounds like the Sestake V Act of 1666, for imposing taxes on us without our consent. Well, they're doing that now. For depriving us in many cases of the benefits of trial by jury, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our government. He's abdicated government here by declaring us out of his protection and waging war against us. Because when they say he's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, it's talking about the Pope's canon Roman law, which is also why millions of people were fleeing Europe at that time because of the Pope's tyranny there. Tyranny is the exercise of power beyond right, which nobody can have a right to, and this is making the use of power anyone has in his hands, not for the good of those who are under it, but to his own private, separate advantage. When the governor, however entitled, makes not the law but his will the rule, and his commands and actions are not directed to the preservation of the properties of his people, but to the satisfaction of his own ambition, revenge, covetousness, or any other irregular passion. 'Tis a mistake to think that this fault only in monarchies. Other forms of government are liable to it as well as that, for wherever the power is put in any hands for the government of the people, and the preservation of their properties is applied to other ends and made use of to impoverish, harass, or subdue them to the arbitrary and irregular commands of those who have it, there it presently becomes tyranny, whether those that use it are one or many. And that's John Locke, Two Treatises of Government, Book 2, Chapter 18, Section 199 and Section 201. With the Spanish Inquisition, an inquisition is one way of proceeding an ecclesiastical court, and other inquisitions and oppressions. The use of information has a long history. For example, in the reign of Henry VII, a very oppressive use was made of them for something more than a century, so as to continually harass and shamefully enrich the Vatican's crown. And that's Blackstone's Commentaries, Book 4. Ecclesiastical, spiritual court are those courts which are held by the kings of authority as the supreme governor of the church for matters which chiefly concern religion, and the laws and constitutions whereby the Church of England are governed are diverse immemorial customs, our own provincial constitutions, and the canon made in convocations, especially those in the year 1603, much oppression having been exercised through the channel of these courts on persons charged with trifling offenses within their spiritual jurisdiction. And that's Tomlin's Law Dictionary, 1835 edition, volume 1. So, you see that kind of stuff going on today, don't you? I certainly do. Which is why my ancestors made the very first article and amendment: Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof. And the Pope's canon Roman law, Sestake Usufruct, was brought into America first with the Pope's 1871 Municipal Corporation at 16 Stat 419. Civil law, Roman civil law are convertible phrases, meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city is established peculiarly for itself, more properly called municipal law. So municipal law is Roman law. And then under the Code of Law for the District of Columbia in 1901, an act to establish a Code of Law for the District of Columbia, the legal estate to be the Sestike Jus at 31 Stat 1432. And the Pope's minor estates, Sestike Usufruct, now codified at 31 CFR 363.6, and are unconstitutional because municipal law was the law of the dependent papal ecclesiastical city-states. This is taken from Encyclopedia Britannica, or New Dictionary of Arts and Sciences, 1771, Volume 2, page 883. Civil or municipal law is that which every sovereign kingdom state has appropriated to itself. The appellation of municipal was originally confined to the laws of the municipia, or dependent states, so it came from the Vatican's dependent city-states. Roman or papal states stretch across the central part of the Italian peninsula in an oblique direction from the Adriatic to the Mediterranean, and between Tuscany, Modena, and Lombardy on the northwest and Naples on the southeast. Area 17,822 square miles, population in 1833, 2,742,000, capital Rome, population 153,000, government and elective monarchy, the Pope for the time being the absolute sovereign with the consulting assembly of cardinals. And that's Waterston Encyclopedia of Commerce and Mercantile Law, 1863. Rome, the capital of the Pope's territories and of Italy, and anciently the Milrus of the Roman Empire. And was also called canon law, the civil or Roman and canon law, though they are perhaps not to be named proper parts of our written law, have undoubtedly had the greatest influence in Scotland. The power exercised by our sovereigns and judges have been justified upon no other ground but that they were conformable to the civil or canon laws. So Roman law and canon law are the same thing. That's taken from Encyclopedia Britannica, 1771. And the Pope's ecclesiastical city-states were annexed to the Kingdom of Italy in 1870, a year before the 1871 municipal corporation enacted by Congress. The formerly Republican leader in southern Italy, Giuseppe Garibaldi, made common cause with the House of Savoy to overthrow the Kingdom of the Two Sicilies, and the people voted in a plebiscite to join Sardinia to form the Kingdom of Italy in 1861. The Papal States and the city of Rome were annexed to the kingdom in 1870, completed the unification of Italy, and are now called Vatican City and the Holy See, and it continues to this day. This is the Lateran Pact, Article 4, 1929. The sovereignty and exclusive jurisdiction over Vatican City, which Italy recognizes as appertaining to the Holy See, forbid any intervention therein on the part of the Italian government or that of any authority other than that of the Holy See shall be there acknowledged. So it's a city-state and is unconstitutional because of Article 1 and Amendment. Congress shall make no law respecting an establishment of religion. And the Pope's necromancy, Sestike v. Usufruct, which is now called a minor estate, is an entity because an entity includes the estate of a living person, such as an incompetent or a minor. And this is taken from 31 CFR 363.6. And a minor can be anyone over the age of 18 who has failed to take control of the securities in this Treasury Direct account. The term minors also refers to an individual who's attained the age of 18 years but has not yet taken control of the securities in his or her minor account. And the Pope's Sestike Usufruct minor estate is a fiction of law which was invented by the Roman praetors under the pretense of doing equity and owe their origin to the legislative usurpations of the bench. And the Pope's fictions of law are necromancy and satanic. And this is Deuteronomy 18:10-12, King James Version. There shall not be found among you anyone that maketh his son or his daughter to pass through the fire, that useth divination, or an observer, enchanter, or a witch, or a charmer, or a consulter of familiar spirits, or a wizard, or a necromancer. For all that do these things are an abomination unto the Lord. Because of these abominations the Lord thy God doth drive them out from before thee. Which puts you under the Commerce Clause, Article 1, Section 8, Clause 3, in violation of Article 1, Section 8, Clause 17, to exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as made by cession of particular states and the acceptance of Congress, become the seat of government. To use the fraud and deception to assault people with a quasi-contract, a fake contract, a sumpsit. In the origin of tort, a sumpsit was soon transformed into an action of contract, which becoming afterwards a remedy where there was neither tort nor contract, based of course only upon an express promise. It was afterwards supported upon an implied promise, and even upon a fictitious promise. Introduced as a special manifestation of the action in the case, it soon acquired the dignity of a distinct form of action which superseded debt, became concurrent with the count, with case upon a bailment and warranty, bills of exchange, and competed with equity in the case of essentially equitable quasi-contracts. Both in Roman and English law, there are certain obligations which were not in truth contractual, but which the law treats as if they were. They're contractual in law, but not in fact, being the subject matter of the fictitious expansion of the sphere of contract to cover obligations which do not in reality fall within it. Which requires the Pope's fiction of law, minor estate / U.S. citizen. Quasi-contracts are based solely upon the legal fiction or fiction of law. Because under the Commerce Clause, the boundaries of the District of Columbia expand anywhere on the planet with their plenary power. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens even when one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And that's National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, U.S. Supreme Court, 1948. Which is why in the Kavanaugh hearings, when he was being interviewed for a Supreme Court appointment, they asked him, can we go after a U.S. citizen in Afghanistan? And he said, yes, you can. And because plenary power is a dictatorship under the Pope's canon Roman law. You'll notice that the bought and paid for administrative clerks masquerading as judges under the Pope's canon Roman law are in bad behavior and fraud upon the court, which are non-judicial proceedings, because whenever a statute's involved, the Pope's fake judge is actually a bought and paid for clerk masquerading as a judge. When acting to enforce a statute and the subsequent amendments to the present day, the judge of municipal court is acting as an administrative officer, not in a judicial capacity. Courts administering and enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent for the involved agency, but only in the ministerial and not a discretionary capacity. It's the accepted rule not only in state courts, but of the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial clerk for the agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency. Which means they're legislators, engaging in legislative acts against a named individual, which is a bill of attainder or a bill of pains and penalties, which are prohibited under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1, and also Article 1, an amendment. Congress shall make no law respecting an establishment of religion, because it's from the Pope's Roman law, also known as canon law, and because they've imposed martial law rule, which is why they took up arms, why we took up arms in 1775. Statutes have been passed extending courts of admiralty and vice admiralty far beyond the ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting life and property, to supersede the course of common law, instead thereof to publish and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charter, as we saw the misery to which such despotism would reduce us, and that's causes and necessities for taking up arms, 1775. Because the Vatican's martial law rule was imposed with a bankruptcy emergency. It's an established fact that the United States federal government's been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. HJR 192, 73rd Congress in session, June 5, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States in the official capacities of all United States governmental officers, and departments, and is further evidence that the United States federal government exists today in name only. U.S. Congressional Record, March 17, 1993. Since March 9, 1933, notice the date, March 9, 1933. Since March 9, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel in a plethora of particular ways, control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. And that's NRE U.S. Senate Report number 93-549, dated November 19, 1973. Look it up. Do a search for it. It's online. It's available. And that's exactly what's in there. It's quite a large report, 607 pages. Because martial law rule is the law of emergency and necessity. Ex parte Milligan. There's three kinds of martial law. There's full martial law when actually invaded by a foreign enemy or insurrection. Troops are put on the street. Martial law proper is the law of the armed forces. When a sergeant tells a private what to do, it's enforced by court-martials. And martial law rule is the law of emergency and necessity. It's used during peacetime and can go on indefinitely. And the Pope's private bar guild members on the bench tell you I can do anything I want. This is, again, the non-ratification of the 14th Amendment by AHL of the Utah Supreme Court. This is a war of the intrusion of the civil law upon the common law. The court Diamond v. Harris calls civil law, which is statutory law, superior equity. And then the cite from that is it's difficult to see how the courts of the state are to ignore the common law rule as a rule of decision when it's made so by statute and adopt a civil law, even though it have the merit of superior equity. Goes on. In the meantime, civil law is a form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has been understood to follow the law. That's common law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following common law, thereby destroying the common law and leaving what's called equity in its place. Because common law is taken from the Holy Bible, and normally equity follows common law. Every system of law known to civilized society generated from or had as its component one of three well-known systems of ethics, pagan, Stoic, or Christian. The common law draws its subsistence from the latter. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It's the guide by which we dissolve domestic frictions. It is the rule by which all legal controversies are settled. But under martial law, equity does not follow common law and can do anything it wants, which is also talked about in the cause and necessities for taking up arms. To supersede the course of common law and publish the order and the use of the exercise of the law of martial, which makes it satanic. And the Pope's private bar guild Satanists are using the Pope's canon Roman law of capitis diminutio. Black's Law Dictionary, capitis diminutio maxima, meaning the maximum loss of status through the loss of use of capitalization. The highest or most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage when he became a slave. It swept away all the rights of citizenship and family rights. Under the Commerce Clause, Article 1, Section 8, Clause 3, to assault people with their penal action for breach of quasi-contract, which is breach of fake contract. A penal action is an action on a penal statute, an action for recovery of penalty given by statute. Where an action is founded entirely upon a statute, the only objective is to recover a penalty or forfeiture. Such action is a penal action. The words penal and penalty in their strict primary sense denote a punishment, whether corporal and pecuniary. Okay, we're going to talk about pecuniary in a minute. Imposed and enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeiture to be forfeited for non-compliance with an agreement. That's for breach of quasi-contract, which is all tied to the Vatican's canon Roman law with their quasi-contract pecuniary cause. Pecuniary cause, such as arise either with the withholding of ecclesiastical dues or the doing or neglecting of some act relating to the church whereby some damage accrues to the plaintiff towards obtaining satisfaction for which he is permitted to institute a suit in the spiritual court. Such, for instance, are the subtraction or withholding of tithes from the parishioner or vicar, the non-payment of ecclesiastical dues to the clergy as pensions, mortuaries, compositions, and the like. And that's taken from Book 3 of the Blackstone's Commentaries, and is cited in Holthouse, A New Law Dictionary, 1850 edition. To populate the prisons by selling people into slavery. He, the prisoner, has as a consequence of his crime forfeited his liberty and all his personal rights except those which the law and its humanity affords him. He is for the time being a slave of the state. And Trump even paid off the Vatican when he commuted Roger Stone's penance. Well, sentence. No, it's penance, which was changed into a sum of money to be applied to pious uses, which is usufruct. Penitentiary is meant a penitent or ordainer of penitence, a place for penitence. Penance is punishment imposed for a crime by ecclesiastical laws. It's an acknowledgement of the offense. Penance may be changed into a sum of money to be applied for pious uses called commuting. And that's taken from Book 3 of the Institutes of Koch's Institutes, Book 3 and Book 4. And so that's Jacob A. New Law Dictionary, 1750 edition. And because of the administrative proceedings under the Pope's canon Roman law, there are more people in prison in America as a percentage of the population than there are in communist China or the Soviet Union, or the worst dictatorship in history. And if there were Christians here, the Pope's private bar guild Satanist bail priests selling in people into slavery would get their necks stretched. If a man be found stealing any of his brethren of the children of Israel, maketh merchandise of him, or selleth him, then that thief shall die. Thou shalt put evil away from among you. And the Innocent Project estimates that 60% of prisoners are innocent. But it's such good business for the Vatican and their canon Roman law so-called courts, which is one of the grievances of the organic law of the Declaration of Independence, 1776. He's plundered our seas, ravaged our coasts, burned our towns, and destroyed the lives of our people, all of which has been planned and orchestrated by the Vatican. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. And that's Roman Catholic Archbishop James E. Quigley, Chicago Daily Tribune, May 5th, 1903. And the Pope, the Vatican, now owns and operates the bankrupt 1871 corporation, as evidenced by the Roman Achaia military staff that's planted on all conquered nations, that's sitting on the right side of the Speaker's podium in the U.S. House of Representatives, and the two Roman fascia bundle of rods bound into a weapon symbolizing under the rule of a single man that are on the wall on each side of the Speaker's podium in the U.S. House of Representatives. And there's a picture. There's the Roman Achaia military staff, and there's the two fascists, which is also why Nancy Pelosi, when she was Speaker of the U.S. House of Representatives, told the members, we can't read this bill until after we pass it, because she was taking instructions from her Vatican handlers, all of which is evidencing the fact that the 1871 corporation currently operating in the District of Columbia is a Vatican-dependent city-state. And the Vatican's Pope Francis recently issued an apostolic letter about jurisdiction of judicial authorities of Vatican city-state and criminal matters that talks about concurrent jurisdiction in other states, which means other papal states, like the District of Columbia and the City of London, United Kingdom Crown. And this is taken from that apostolic letter. When the same matters are prosecuted in other states, the provision in force in Vatican city-state on concurrent jurisdiction shall apply. And that came into force on 1st of September 2013. And the Vatican's Pope Francis came and addressed his own and operated Congress on 24th of September 2015, and the Pope's satanic private bar guild member bail priests are assaulting people with their Roman fiction of law, minor estate, sestike use, usufruct, trust, necromancy, with the provisions, with presumptions of jurisdiction. Presumptions like the office of trustee, because the sestike be usufruct minor estate, and presumption of suretyship. You are noticed that everything in the District of Columbia, including your Federal Bureau of Investigation military police, is owned and operated by the Vatican. You're noticed that Will Livingston ratified this Constitution for the United States on behalf of New Jersey, 1787, as my fourth great uncle, which means on posterity, as found in the preamble. And I'm entitled to right of blood. And the right of blood cannot be destroyed by any civil law, because all the laws of Congress and all the laws of Texas are civil laws. And this is the maxim of law that talks about that. And all courts are operating under power which is derived from me as posterity. And the maxim says the power which is derived cannot be greater than that from which it is derived. Therefore, it's impossible for me to give you or your private bar guild handlers or your Vatican so-called court any authority over me. And John Marshall, Chief Judge of the Legislative Supreme Court of the United States, agreed and said it's impossible for me to confer a sovereignty which will extend over me. And this is McCullough versus Maryland. The sovereignty of a state extends to everything which exists by its own authority or is introduced by its permission, but it doesn't extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States. We think it demonstrable that it does not. Those powers are not given by the people of a single state. They're given by a people of the United States to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer a sovereignty which will extend over them. And I am exempt from you and your Vatican corporation and their Vatican-owned and operated private bar guild handlers, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And I require courts to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory of the property belonging to the United States, which is the supreme law of the land. Anything in the constitutional laws of any state to the contrary notwithstanding, Article 6, Clause 2, and we the people failed to be the Vatican's U.S. citizens because a 14th Amendment U.S. citizen failed to exist when the Constitution was written. And your civil laws of Congress and civil laws of Texas only apply to corporations. And this is Penhallow versus Doan's administrators. Inasmuch as every government is an artificial person, an abstraction, a creature of the mind only, a government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating or attaining parity with the tangible. The legal manifestation of this is no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate artificial persons and the contracts between them. You'll notice that as posterity, I'm entitled to common law, not canon law or Roman law by right of blood, as described in Article 6, Clause 2 of this Constitution. This Constitution, the laws of the United States, which shall be made in pursuance thereof, and all treaties made, which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. And it's also found in the Judiciary Act of 1792, saving to suitors all cases the right to a common law remedy where the common law is competent to give it. And that's 1 Stat 77, Section 9A. And the Judicial Code of 1911, third of all causes of admiralty, maritime jurisdiction, saving to suitors in all cases the right of a common law remedy where the common law is competent to give it. Because the law of the land phrase is convertible phrase with the phrase common law. The principle that no person shall be deprived of life, liberty, or property except by due process of law did not originate in the American system of constitutional law, but was contained in the Magna Carta, sometimes referred to as Chapter 29, conferred on the 19th day of June, 1215, declared no freeman shall be taken or imprisoned or seized or outlawed or exiled in any way destroyed, nor shall we go upon him, nor send upon him, but by the lawful judgment of his peers or the law of the land. It has been said that the principle was known before Magna Carta and was originally designed to secure the subject against arbitrary action of the crown and to place him under the protection of the law. It was settled beyond question that this principle came from England to America as part of the common law and has been a fundamental rule in common law. When first adopted in Magna Carta, the phrase law of the land had reference to the common law and has been the fundamental rule in common law. And that's Book 16, American Jurisprudence, 2nd edition, Constitutional Law, Section 543. And common law as the law of the land has always been here long before the government was here. The individual may stand upon his constitutional rights as a citizen. His rights are such as existed by the law of the land long antecedent to the organization of the state. That's common law before, okay? So antecedent means before, long before. So it was here from the beginning of time. And because your Vatican maritime codes only apply on the high seas and up to the high water mark or the first bridge of any navigable river, and the District of Columbia or any federal enclave is found in Article 1, Section 8, Clauses 17 and 18. And there's no common law in your Vatican-owned and operated District of Columbia, United States District of Columbia, or its Vatican-owned and operated subsidiary called the State of Texas. And your civil laws of Congress and civil laws of Texas only apply to corporations, which are things, under canon Roman law. You are noticed that Article 1, Section 1 of this Constitution for the United States of America says that all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a House and a Senate. And Article 1, Section 8 says the Congress shall have power to, and Clause 9 says to constitute tribunals inferior to the Supreme Court. I think I'll make that size 12. Which means the Supreme Court referred to in Article 1, Section 8, Clause 9 can only be referring to our one Supreme Court, a common law court of the people, by the people, and for the people that existed prior to the Constitution, because the Supreme Court currently located in the District of Columbia, it's a legislative court set up by the Judiciary Act of 1789. And one of your subordinates has been asking about the Republic of Texas and our common law court, which is none of your concern, because the Republic of Texas never did join the Union. For any sovereign nation to join another sovereign nation, they have to do a treaty of annexation, which Texas did do, and send it to the U.S. Senate for approval and adoption. But the U.S. Senate shelved it, and the U.S. Congress did a House Joint Resolution instead, which means Texas never did join the Union, and the Republic of Texas was in abeyance. Furthermore, the Supreme Court dismissed a case brought by the people of the Republic of Texas for lack of jurisdiction, a true copy of which is attached here to, all of which is incorporated herein by reference in its entirety. And Article 7, an amendment, says no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. And I have lots of first-hand knowledge how the Vatican's bill priests and your so-called courts are not competent to deal with common law, and absolutely refuse to deal with common law, because they operate exclusively under canon Roman law, dealing exclusively with their minor estate. And your legislative inferior court of the United States said in Ex parte Milligan that you're required to recognize our common law courts that are peacefully trying to offer a superior alternative to your Vatican-owned and operated ecclesiastical so-called courts with your Vatican-owned and operated private bar guild bail priests that absolutely refuses to recognize common law, but are busy populating the prisons with their Vatican tyranny by making war on we the people, as evidenced by the Affidavit of Life and the mandatory judicial notice of 12 presumptions and the notice of void judgment, certified copies of each of which are attached hereto, all of each of which are incorporated herein by reference in their entirety. You are noticed that you operate exclusively under color of law, and I demand and have my God-given rights as affirmed and secured by the organic law of the United States of America the Declaration of Independence, the Articles of Confederation, the Northwest Ordinance, and this Constitution for the United States of America, not to be subjected to your foreign martial law jurisdiction under color of law. Color means a semblance, and there's some sites on color of law. Your notice is implied in your oath that I am not a person as far as your statutes are concerned, because a person is a variety of entities other than human beings, foreigners, not citizens. Person, the term may be include labor organizations, partnerships, legal representatives, trustees. Scope and delineation is determined in the 14th Amendment. And a sovereign is not a person in a legal stand as far as the statute is concerned. In common uses, the term person does not include the sovereign, and statutes employing the word are normally construed to exclude it. Sovereign is not a person in a legal sense. Henry Fox, U.S. versus Fox. That was actually Robert Fox, and I talked to him on the phone. He's passed away now, but I remember talking to him. You're noticed as implied in your oaths that the only legitimate power that is held by any governmental entity is power that we the people delegated, and we the people are not subject to your codes, rules, and regulations, and I demand and have my God-given right to complete and total access to all of my common law rights as affirmed and secured by the Declaration of Independence, the Northwest Ordinance, the Articles of Confederation, and this Constitution for the United States of America. Sovereignty, of course, is not subject to law, for it is the author and source of law, but while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts. Governments are but trustees acting under derived authority, have no power to delegate what's not delegated to them, but the people as the original fountain might take away what they have delegated and entrust to whom they please. The sovereignty in every state resides in the people of the state, and they may alter and change their form of government at their own pleasure. Our notice is implied in your oath that I'm a sovereign citizen, as evidenced by the resolution of Congress. Because we have a Republican form of government, we're all sovereign citizens, as evidenced by House Joint Resolution 183, dated May 9th, 1940, at 54 Stat 178, says in the preamble, whereas it's desirable that the sovereign citizens of our nation be prepared for the responsibilities and are impressed with the significance of their status in our self-governing republic. And is affirmed by Harold M. Stevens, Chief Judge of the United States Court of Appeals for the District of Columbia, in his article on the American Bar Association Journal, Volume 37, Number 4, April 1951, entitled Citizenship, the Real Profession of Every American. If our sovereign citizens were not informed upon their such subjects, how can they intelligently participate in the determination of pertinent national policies? And if you or your subordinates participate in war crimes against me or anyone claiming to be sovereign, like we're some sort of a terrorist, like Obama did and Biden did, you'll be engaged in treason and sedition against the Republic, as well as perjury of oath and other felonies. Your notice is implied in your oath that you have no immunity whatsoever, because all officers of all governments are presumed to know the law, and the Constitution of the United States of America requires it. And I demand and have my God-given rights, have all of those private men and women acting as public servants are held to their oaths and all that their oaths imply. An officer who acts in violation of the Constitution ceases to represent government. Ignorance of the law is not excuse misconduct in anyone, least of all a sworn officer of the law. Your notice of the Vatican's so-called 14th Amendment is canon law, and from what is now the Vatican, and for slaves. 14th Amendment referred to slavery. Your notice is implied in your other oath, which creates a trust. And you are my agent. The government is an agency of the state being the sovereign people. The state does not owe its origin to the government of the United States in the highest or any of its branches. It was in existence before it. It derives its authority from the same pure and sacred source as a self, the voluntary and deliberate choice of the people. Your notice is implied in your oath that because I'm a sovereign living soul and a holder of the office of the people, inhabitant of the land of Texas, it also holds true I'm not a person as found in your corporate commercial codes, rules, and regulations, and therefore your law merchant, aka private international law, aka martial law, aka canon law, does not apply to me. And if you, your successors, or any of your subordinates attempts to impose one of your law merchant's so-called contracts upon me, your subordinate and you will be engaging perjury of oath, sedition, and treason, as well as giving aid and comfort to the enemy in a time of war. And all judgments entered into my case are void judgments, and I can collaterally attack them at any time and any place, because the courts have further decreed want of jurisdiction makes all acts of judges, magistrates, U.S. Marshals, sheriffs, local police, all void, not just voidable, void. You'll notice that the use of any statutes, codes, rules, regulations, or court citations within a document created by me at any time is only notice that which is applicable to you, and is not intended, nor shall it be construed to mean that I have conferred, submitted to, or entered into any jurisdiction alluded to thereby. On YouTube, somebody's wanting to know how to get a copy of this document. I'll upload it to Google and put it in the show notes. Your notice is implied in your oath that while I do travel on the land of Texas or elsewhere on Turtle Island from time to time, I am not even remotely interested in being in your Vatican corporation called United States, or any of its political subdivisions called State of Arizona or State of Texas or State of Delaware, and any such municipal corporations. And I shall not be in any of your Vatican-owned and operated municipal corporations. And any attempt by you or your subordinates to coerce or intimidate me into your Vatican-owned and operated municipal corporation is perjury of oath, treason, and sedition at a minimum by whoever does it and you. I'm going to step aside for a minute. I'll be right back.
Mary, were you able to locate that document? Oh, she's not in here anymore.
Thanks for trying to help her, Ruby.
You know.
Okay, I'm back. Did somebody have something they wanted to say?
Yeah, I've got a couple of questions, but I'm going to wait till the end and
Okay.
let everyone else have a chance to ask.
Okay, well, we're on page 22, so we got another 11 pages. Your notice is implied in your oath that my rights are unalienable as found in the positive law embodied in the Declaration of Independence, which means they cannot be alienated under any circumstances, and you and your subordinates know this because they always criminally convert my name in some way for your Vatican handlers, with all block capital letters, into a dead thing to facilitate their violation of my rights. Your notice that the so-called courts in the United States are corporate commercial courts, tribunals, and operate exclusively under martial law, which originates with canon law in the Vatican in violation of God's law. And the United States District Court is not a true United States court established under the Constitution, Article 3, to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3 of making all needful rules and regulations respecting the territory belonging to the United States. Your notice is implied in your oath that I'm not one of your Vatican handlers, 14th Amendment U.S. citizens. And here's a bunch of citations. As a state citizen, I'm one of the sovereign people and a part of the sovereign body of people, and I have all the rights of the king. And governments are my agents with authority that I delegate, and everything they do with authority is under my authority and consistent only with the four corners of lex scripta and lex non scripta. And to do otherwise negates their authority, thereby turning them into criminals and usurpers of the law. And there is nothing the government can do to affect the people. Sovereignty itself is not subject to law, for it is the author and source of law, but in our system, all sovereign powers are delegated to the agencies of government. Sovereignty itself remains with the people by whom all government exists and acts. There is no such thing as the power of inherent sovereignty in the government of the United States. In this country, sovereignty resides in the people, and Congress can exercise no power which they have not, by their Constitution, entrusted to it. All else is withheld. As a member of the sovereignty, I'm completely immune from those laws inconsistent with lex scripta and non scripta. The state citizen is immune from any and all government attacks absent contract. Rights of individuals are restricted only to the extent they voluntarily surrender by citizenship to the agencies of government. State citizens are the only ones living under free government and whose rights are incapable of impairment by legislation or judicial decision. State citizenship is a vested substantial property right, and the state has no power to divest or impair those rights. The sovereignty of a state does not reside in the persons who fill the different departments, but in the people, and from whom the government emanated, and they may change it at their discretion. Sovereignty then in this country abides with the constituency and not with the agent, and this remark is true both in reference to the federal and state governments. And as a sovereign, I'm also a non-taxpayer. Persons who are non-taxpayers are not within the system and can obtain no benefit by following procedures prescribed for taxpayers, such as filing of claim for refunds. Revenue laws are a code or system of law, tax assessment and collection. They relate to taxpayers and not to non-taxpayers. The latter are without their scope. No procedures are prescribed for non-taxpayers, and no attempt is made to annul any of their rights and remedies in due course of law. With them, Congress does not assume to deal, and they are neither the subject nor the object of revenue laws. Taxpayers are not state citizens. And any attempt to cause me injury with their so-called prosecutions is a common law crime of bearing false witness, adultery, theft, Baal worship, necromancer, and other transgressions of the law set out in the Pentateuch, a modern language barratry. No action can be taken against the sovereign in the non-constitutional courts of either the United States or the state courts, and any such action is considered a crime of barratry. Barratry is an offense of common law. Because I'm a state citizen, I'm also a judicial power citizen. Judicial power is the right to hear those matters which affect life, liberty, or property of citizens of the state. Your notice is implied in your oath that the rights of state citizens are unaffected by the Vatican's so-called 14th Amendment. The rights of the original citizens of the states as such are not under consideration in the 14th Amendment. They stand as they did before the 14th Amendment and are fully guaranteed under other provisions. And all of this is because of the law of nature as described by Blackstone and common law. The first 10 articles of an amendment to the Constitution for the United States of America are intended to protect certain common law rights from the federal government. And the law of the land is common law and not a statute. And all of these rights, I can probably take this out because I already read this. And all of these rights and other common law rights are only affirmed by the Magna Carta and the Constitution for the United States of America, and they exist long prior to the existence of any government. And I have the right to do anything as long as I cause no damage to no man, woman, or child or their property. And my rights are not defined anywhere because I have unlimited rights. You'll notice, as implied in your oath, that you have no immunity when dealing with me. Your notice is implied in your oath that there are no judicial courts in America and have not been since 1789. Your notice is implied in your oath that the Vatican's U.S. citizen defined by the so-called 14th Amendment has to be completely subject to the jurisdiction of the United States and therefore is not one of we the people, but is a corporation or a cestui use or other fictitious entity. And this is persons declared to be citizens or all persons born or naturalized in the United States and subject to the jurisdiction thereof. The evident meaning of these last words is not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject. It is evidence that they, U.S. citizens, have not political rights or vested in citizens of the states, or not constituents of any community in which is vested in any sovereign power of government. Their position partakes more in the character of subjects than of citizens. They are subject to the laws of the United States, but have no voice in its management. If they're allowed to make laws, the validity of these laws is derived from the sanction of a government in which they're not represented. Mere citizenship they may have, but the political rights of citizens they cannot enjoy. The term citizen in the United States is analogous to the term subject in the common law. And the Vatican's U.S. citizen is a fictitious entity and has no rights. Therefore, U.S. citizens residing in one of the states of the Union is classified as property and franchises the federal government as an individual entity. Again, it's a fiction. In our opinion, it is not the intent of the legislature to restrict the operation of the statute to those only who were subjects of the federal government. On the other hand, the 14th Amendment, upon the subject of citizenship, declares that all persons born or naturalized in the United States and subject to the jurisdiction are citizens of the United States and of the state wherein they reside. Here is a limitation to persons born or naturalized in the United States, which is not extended to persons born in any place subject to their jurisdiction. A U.S. citizen, upon leaving the District of Columbia, becomes involved in interstate commerce. As a resident, does not have the common law right to travel of a citizen of one of the several states. The right to trial by jury in civil cases, guaranteed by the 7th Amendment, the right to bear arms, guaranteed by the 2nd Amendment, have been distinctly held not to be privileged immunities of citizens of the United States, guaranteed by the 14th Amendment, against abridgment by the states. And in effect, the same decision has been made in respect to guaranteed against prosecution, except by indictment of a grand jury, contained in the 5th Amendment, and in respect to the right to be confronted with witnesses, contained in the 6th Amendment. Privileged immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments against the federal Constitution, to the federal Constitution against the powers of the federal government. The 14th Amendment referred to slavery, consequently the only persons embraced by its provisions for which Congress has operated to legislate in the manner those then in slavery. All citizens of the United States have the same right in every state and territory as enjoyed by white citizens thereof to inherit, purchase, lease, sell, convey real or personal property. That's current law, 42 U.S.C. 1982. Because the Vatican's U.S. citizen is a subject that may also be taxed, Slater's protestations to the effect that he derives no benefit from the United States government have no bearing on his legal obligations to pay income tax. Unless the defendant can establish that he's not a citizen of the United States, the IRS possesses authority to attempt to determine his federal tax liability. If a taxpayer is assessed to a trust, and a taxpayer is assessed to a trust that belongs to what is now your Vatican handlers. Every taxpayer is assessed to a trust, sufficient interest in preventing abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. Therefore, a Social Security number is a number for a Sesticate Trust, U.S. citizen, minor estate, and has no rights except those granted by Congress. The only absolute and unqualified right of a U.S. citizen is to residence within the territorial boundaries of the United States. After the adoption of the 14th Amendment, a bill which became the first Civil Rights Act was introduced in the 39th Congress, the major purpose of which was to secure to the recently freed Negroes all the civil rights secured to white men. None other than citizens of the United States were within the provisions of the Act. And Vatican's U.S. citizen has no right to the custody of their children. Civil rights under the 14th Amendment are for federal citizens, not state citizens. Federal citizens have no right to the custody of their infant children except subject to the paramount right of the state. And the Vatican's so-called 14th Amendment converted citizenship into the opposite of what the Founding Fathers intended for what is now your Vatican handlers. And while the 14th Amendment does not create a national citizenship, it has the effect of making that citizenship paramount and dominant instead of derivative and dependent upon state citizenship. The term resident and citizen of the United States is distinguished from a citizen of one of the several states in that the former is a special class of citizen created by Congress. Our notice is implied in your oath that I shall completely ignore your codes, rules, and regulations because they do not apply to me, and if any of your subordinates perceive any obedience by me to any of your codes, rules, and regulations, it shall be viewed to be a mistake or an accident. Except to say that if I expect common law remedies, I have to accept common law responsibilities, which means that I have to respect other people and their rights, including their right not to be injured by me. Therefore, if I travel safely, as an example, if I'm following a speed limit, it is not to be viewed by you or your subordinates as because I'm concerned about following any of your codes, rules, or regulations, but it should be viewed that I'm trying not to cause injury to my neighbors who are also on the road, or my neighbors who are beside the road. You're noticed that my rights are unalienable as affirmed by the U.S. Declaration of Independence, which means that any evidence of any so-called contract and with any agency of the government, all corporations and fictitious entities is a nullity, and your so-called privileges extend only to persons and things, and I am neither. The rights of sovereignty extend to all persons and things not privileged that are within the territory. They extend to all strangers resident therein, not only to those who are naturalized and to those who are domiciled therein, having taken up their abode with the intention of permanent residence, but also to those whose residence is transitory. All strangers are under the protection of the sovereign while they are within his territory and owe a temporary allegiance in return for that protection. And that's Carlisle versus United States, 1873. You'll notice that under Article 11 Amendment that the Constitution of the United States, no federal official or agent has any authority over me whatsoever, and they have no authority to even communicate with me, and you are the one who is required to stop them from violating my rights. The judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against any one of the United States by citizens of the United States or by citizens or subjects of any foreign state. You'll notice that if the Attorney General is the highest law enforcement officer, he's required to protect my rights, and you are working for the Attorney General, so then so are you. It is true that at common law, the duty of the Attorney General is to represent the king, he being the embodiment of the state, but under the democratic form of government now prevailing, the people are king. So the Attorney General's duties are to that sovereign rather than to the machinery of government. You'll notice that you have 30 days from the date to receive this communication with a 15-day extension if requested to respond or dispute anything in this private agreement and notice and demand, and your failure to dispute each paragraph on a paragraph-by-paragraph basis shall constitute your acceptance and approval with full knowledge and consent and a private agreement to all paragraphs, and in the event that you fail to respond or otherwise dispute anything in this communication, you, your successors, your subordinates agree and consent to be held personally responsible civilly and criminally for any injury made against me by you, your subordinates, or your successors on the land of Texas, and shall forever yield to the doctrines of estoppel by acquiescence, waiver, and fraud. You'll notice that in the event that you dispute a specified fact in this agreement and fail to provide proof of such error of the specified fact, that there is in fact no dispute, and the specified fact and all other points in our private agreement are still in full force and effect. You'll notice that each paragraph of this document may be severed from all of the others. Therefore, in the event that you have an issue with one paragraph, or you provide notice of such issue and proof of such error of the specified fact within the time allowed, all other points in this notice and demand are still in full force and effect. Your notice is implied in your oath that you can no longer claim good faith, and this is Texas Code of Criminal Procedure, No evidence obtained by an officer or other person in violation of any provisions of the constitutional laws of the United States of the state of Texas or the constitutional laws of the United States of America shall be admitted in evidence against the accused on the trial of any criminal case. And then paragraph B, it is an exception to the provisions of subsection A of this article that the evidence was obtained by a law enforcement officer acting in objective good faith reliant upon a warrant issued by a neutral magistrate based on probable cause. What a charade. Anyways, and then this is 18 U.S.C. 2707, civil action. Defense. A good faith reliance on a court warrant or order, a grand jury subpoena, a legislative authorization, or a statutory authorization, including a request of a governmental entity under Section 2703F of this title, a request of an investigative law enforcement officer under 2518.7 of this title, or a good faith determination as Section 2511.3 of this title permitted, the conduct complained of is a complete defense to any civil or criminal action brought under this chapter or any other law. And that after you receive this notice and demand, if you proceed any further, you are deliberately and calculatedly perjuring your oath by imposing your equity under martial law, which is for persons only, which is conversion of my citizenship from the land of Texas to the foreign jurisdiction of the Vatican's United States in violation of Article 1, Section 8, Clause 17. People of the state are entitled to all the privileges which belong to the king by his prerogative. It will be admitted on all hands with the exception of powers granted to the states and the federal government through the constitutions. The people of the several states are unconditionally sovereign within their respective states. One sovereign does not need to tell another sovereign that he or she is sovereign. The sovereign is merely sovereign by his very existence. The rule of America is that the American people are the sovereigns. You'll notice that if you proceed any further against me and your subordinates will have violated my rights under the color of law in violation of your Code of Law for the District of Columbia, now known as Title 18 U.S.C. 242, and you will have conspired to threaten, coerce, injure, intimidate me, and injure me in the free exercise of my rights under to ignore your color of law rules and regulations pursuant to your Code of Law for the District of Columbia, now known as Title 18 U.S.C. 241. And you'll be subjecting me to your satanic religious ceremony in violation of your Code of Law for the District of Columbia, now known as Title 18 U.S.C. 247, damage to religious property, obstruction of persons, and free exercise of religious beliefs. You'll notice that you shall protect my God-given right not to participate in your satanic commercial system, being mammon, and also protect my right to honor God's law. You'll notice that after saying all of this, I also want you to know that when you're operating in your official capacity as a peace officer, if you ever need me to give you aid in carrying out your lawful duty, I fully comprehend my duty in that respect, and I'll be there for you anytime, any place. You'll notice that you, your successors, your subordinates shall protect me against all foreign agents, including but not limited to the FBI, the CIA, the U.S. Marshals, the IRS, the NSA, the city police, the state police, any other police, U.S. Customs, or any other foreign agents who are or may yet be on the land known as Texas or elsewhere on Turtle Island from time to time. You'll notice that I'm fully cognizant of how your Vatican Jesuit and handlers intend that I turn up dead in support of your targeted justice agenda and your intent to refuse to investigate the felonies against me because it makes so much business for your Vatican so-called courts, and because you intend that I exercise my right to resist your unlawful arrest with lethal force if necessary. An illegal arrest is an assault and battery, as evidenced by the Amistad. That's United States versus Schooner Amistad, where the people killed all of their captors except for one because they failed to know how to sail. And the legislative inferior U.S. Supreme Court dismissed the murder charges and ordered them to be returned to Africa. So you can have an excuse to murder me. So you and the Vatican's bankster thieves can pillage the fake money in the minor estate treasury direct account with the Treasury under the Hague Convention concerning the international administration of the estates of deceased persons, concluded 2 October 1973. And while I am not suicidal, I fail to fear death, because we were all here before this universe was created, and we'll all be here when it goes away. And I have never in my life breached the peace, and my conscience is clear. But you and your military police breach the peace on a routine basis with your unlawful arrests and your kidnappings and your assaults and your murders. And before God, angels, and anyone who reads this document as a witness, I shake the dust of the earth from off my feet against you. And we'll be talking about this on Judgment Day before the one true God. And if I do turn up dead, this shall be my deathbed testimony. Signed and sealed in red ink on the land of Texas under penalty of perjury. And that's it. That's page 33. And I might shrink this down some more, but that's pretty well got it. Does anybody have any questions? This is my notice of time extending.
Ooh, that was something else.
I have a question. Sorry about that, Ruby. I would like to know if you on the wall to the minor changes that you made earlier about an hour ago, so it'll reflect. Because I mean, so well spoken. There's also something else, but I forget now. I apologize. I'll think of it one moment.
Okay. Well, I'm not sure what that was all about.
I would like to know what you have posted on the wall with this masterpiece, please. You have great verbiage in here. Thank you.
Well, I uploaded it to the group. Now, that was before I made a couple changes. Do you want me to upload it again? And I guess I could delete that one.
Thank you very, very much.
Sorry, I can't hear you.
Thank you. Thank you. I appreciate your doing this. I learned so much from you. Thank you.
I'll upload it again.
Ruby, did you have a question?
Oh, I'm not sure if I'm coming through clearly or not.
I can hear you.
Okay. No, I was just gonna say, I know you were gonna revisit pecuniary, and I also wanted to know if when we're talking about planetary, is that just the same as like international or universal?
Well, pecuniary, let's go back to there. And I'm not sure the other question, the other word that you were wondering about.
I don't think I'm saying it right. The plenary.
Plenary?
Yeah, that one.
Okay, here's pecuniary. So it says here the words penal and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary. Okay? Well, and so that's non-compliance with agreement. Pecuniary cause. Let's write this next right here. Such as withholding ecclesiastical dues or withholding tithes from the parson or vicar, non-payment of ecclesiastical dues to the clergy. It's all the Vatican, okay? If it's pecuniary, it's the Vatican. Corporal is where, corporal punishment is where you get paddled. But pecuniary is they just want money. And it's the Vatican. It's all tied to the Vatican. Now, penal is, that's dictatorship. I think that's up here. Penal is, plenary. Plenary is dictatorship. A plenary jurisdiction, that comes from the Vatican again. Might be down. Yeah, it is down. Plenary comes from the Vatican. But if you go to penal, remember a bill of pains and penalties. It's penal. That's where penalties, penal. It's all the same words. Bill of pains and penalties. And here, penitentiary, a penitent, ordainer of penitence, penances, right? Penance is a punishment imposed for a crime by ecclesiastical laws. That's why they call it a penitentiary, because it's the Vatican. Punishment, penances can be changed into a sum of money to be applied for pious uses called commuting. So Trump paid off the Vatican when he commuted Roger Stone's sentence. It was a penance, really. Anyways, and then plenary is dictatorship, it's total power, and penal is Texas Penal Code. Oh, right here. Here's penal. Penal action is an action on a penal statute. It's quasi-contracts. It's all about quasi-contracts. X is founded on a statute. The only object is to recover a penalty, a penal action for a penalty. Right? A bill of pains and penalties, which is unconstitutional. The words penal and penalty in the strict primary sense denote a punishment, whether corporal or pecuniary. So there's two kinds of punishment. They can give you the lash or demand fake money. Or pecuniary, I suppose maybe you could go to jail too.
What type of cases are you filing this into, may I ask, please?
Sorry, I didn't hear that. What was that?
Loud. I was wondering, what kind of case are you filing this into, please?
Actually, I'm sending it to the FBI special agent in charge. It's meant to nip it. He's asking, their FBI's asking some questions about me, and so it's none of their business. And so I'm going to nip it in the bud. You know, it's all warfare. The best defense is a good offense. So you have to understand that that you attack them before they attack you. Is the way it has to work. If you want to be free, you got to be, the best defense is a good offense. I've always done it this way. If I have a hint that something's going down about me, then and this is going to go to Donald Trump, and this is going to go to Pamela Bondi, and I'll bet you that if he doesn't decide to back off and go and find someone else to mess with, I'll bet you he'll get a phone call. And somebody will decide it for him. I guess we'll see.
Would you also send it to the Department of Justice just to have heads up as well?
I can't hear what you're saying.
Would you also send it to the Department of Justice just to give them the heads up as well?
It's going to Pamela Bondi. Okay, she's the Attorney General. That's what we talked about at the very beginning.
Apologize. I missed part.
Maybe you weren't here. Right here.
Correct.
See here? It's going to Donald Trump, it's going to Pamela Bondi, and it's going to Nancy Larson, who was the acting U.S. Attorney.
Are you going to mention about these folks want to talk to me? So, is that what you're going to say to them or no?
No.
First of all, there's a friend of mine. He actually is my brother-in-law's brother, and he was hooked on OxyContin, and he committed suicide. So he's not with us anymore. But I'm not going to mention his name. But it was a guy he was a big guy. He was like about 6'5". He was really big, and he was heavy. He's probably, maybe 300 pounds, and he didn't look that fat. Anyways, he worked part-time as a bounty hunter. And He told me a story one time. He told me how he had arrested a lady with another bounty hunter. Him and another bounty hunter went and arrested a lady. And he swore up and down that she was the right person to arrest. But there became a controversy as to whether she was the right person to arrest. And there was a big investigation. This was in Arizona. And what happened is they got subpoenaed. Okay, him and the other bounty hunter both got subpoenaed to come and testify. And the other bounty hunter went and testified, and he didn't. And the other bounty hunter went to jail, and he didn't. So, there's YouTube videos that say, don't talk to the police. How many times do they have to say that? Don't talk to the police. You see it happen all the time. They did that with Roger Stone, and they did that with General Flynn. You go and talk to the police, and then they accuse you of lying, and that's obstruction of justice. And it doesn't matter what the investigation was about. You get to go to jail for obstructing justice, and they just make it up. So don't talk to the police under any circumstances. So I'm going to make it so they don't want to talk to me.
When you say the crown, are you talking about that the statutes and codes belong to the Vatican crown, or do they belong to the Crown Corporation in London?
Is there a difference?
Well, I have their manual. So in their manual, what I put in my paper was that due to the fact that they had copyrighted all their material, and under the Copyright Act, it states that we are not allowed to perform what is written for between an employer and its employees or of the author, that you're not allowed to perform that. Otherwise, you would be in violation of the law. And it says that it's actively enforceable. So I feel like the moment you begin conversing with them, you have just violated their Copyright Act, and you are trying to take the law into your own hands, because it's copyrighted to them. It even specifies not the federal codes, because the federal codes are not copyright, but it stated that lower inferior courts are allowed, if they wanted to, that it wasn't recommended, they could copyright their laws. And like in Florida, I had a case, and I wrote this in there, and I copyrighted my own material, and I gave them 3 sheets of paper, since you need 3 things to prove as evidence. And I went to the bottom of different parts of the statutes, and on the bottom it says copyright the Florida legislators. So I circled each one, and I told them, like, what is this, and this, and this. That's what I wrote next to my exhibit. And I told them, therefore, I believe it is safe to say that I may not partake in this subject matter, for the reason being that I would be violating the copyright, which is actively enforced by the Crown Corporation. And then they all got an injunction.
Okay, did you watch the rest of this video? Did I watch where I went through and I showed how the Vatican owns the DC?
Yeah, and do they also own I'm asking you because I was reading a book called Occupy Planet Earth, and they're claiming that the Vatican is who wrote the Constitution, and all of the signers, he blew it up, the document. It shows that they were only witnesses to the Constitution. I don't know who signed off on it. It didn't really show who signed off on it, but all of them signed off as witnesses. It says in witness whereof, and they all signed it. But supposedly, the guy is saying that the Vatican wrote the Constitution, just like the Vatican writes the Bibles, they created like the last laws, which were Islamic. They wrote that too. They control all the Bibles. So you would actually have to come in as a Protestant to reject everything. I didn't come in as a Protestant, but I did use their copyright laws, and I got 6 injunctions.
You know, that's interesting that you say that, but I think that there's stories about the Constitution. That there was a story about that they had the doors locked, and when the doors were locked and nobody was supposed to come in, somebody appeared in there and told them how important what they were doing was. Which suggests maybe an ET or something like that. I don't know. But so I've considered that the Vatican. I think the Constitution was inspired by God. Quite frankly, I mean it's full of all sorts of stuff that we don't even understand, or most people don't understand. I mean, I use it all the time, and I bring it up in this. In this document that I use here, but so I think that I don't know anything about this. The Vatican wrote the Constitution, and I don't think that that's the case. But the Vatican does own the District of Columbia because it got seized in the bankruptcy. And the Vatican owns the Crown of England, and so the Crown is the Vatican, and so I don't and that's what I say in here. I mean, if you were listening, that's what I say in here.
I think I missed the beginning of your document, which was actually excellently written. What I do is I can't give an injunction to the clerk so that she can file my documents, but everybody else was entitled to an injunction, an estoppel actually. I don't know how the guy obtained the knowledge about the Vatican writing the Constitution, but like in another book I'm reading, it's called The Achilles Heel, they show you that they wrote that all men are created equal. This is before the Constitution. And then the guy says that when they write the Constitution, they actually slash all of the things that they promised, like in the preamble, like then men are not created equal, because when the Constitution was written, it was only written for the white man. You had to be 21, you would be able to vote, and it was nobody else. And I also looked up the colonizing of America, which is when they take the 13 colonies, everything found on the land became property of these people that were colonizing, I guess for the crown. And, they were getting away from this evil king, but they're probably having to deal with 2 kings, the Vatican king and their King of England, because we actually have 2 kings there all the time. The Vatican is always in the forefront of all that's happening. And when we did 1933 in the bankruptcy, the Pope came and consecrated the land. He physically came here and consecrated. But consecrate could mean a blessing, but it also can mean that he cursed the land. And the Bible says, yeah.
I don't know where you're getting your information from, but really, I mean, you think about it. If King John gave the kingdom to the Vatican, and then to what is now the Vatican, and then agreed to rent it back, then they're the owners, And so, can King John do anything? He's doing everything under instructions from the Vatican. And that's all there is to it. It's like the boss. Who's the boss? The boss doesn't, if you do something on your own, it's under the boss's permission. And so it's everything coming from the Vatican. And I don't know I can't imagine how you could see it any other way.
You are correct on this. But I think it's because there's a pyramid of, what do you call that, of hierarchy, that I think you have to go through one of the three, which is United States, that District of Columbia, and London, the Crown. They control all the monetary, and the Vatican itself. That's the Trinity. I agree with you what you're writing.
May I? What I found out through studying Supreme Court cases, Republican form of government, people, everybody is participating, writing laws. So no one man called king strike these constitution. So a body politic called people actually wrote it. Everybody is in it. And we wrote it 8 days.
The body politic in their world means a society of men. It did not mean that everybody wrote this. You got to go look it up, because I posted it the other day what body politic meant. They're very smart.
Not body politic, but people as one body. They actually are Republican form of government, means people are a governing body, and the government is an agent. They are not kings.
I'm gonna end all of this discussion, because this is you want to talk about that, you can talk about it after I'm done, because I'm gonna sign off from here. If I happen to I have a republic is it's representative government, and so it is a society. I understand that it's a corporation. Well, it's a trust actually, but they still have an oath of office. Let me finish. I'm going to cut you off here in a minute. They have an oath of office, and they're supposed to be representatives, and so now there's things that have happened that like the Senate being elected instead of appointed by the governors. That basically, to a large degree, nullified the republic, and the Vatican basically owns, the DC right now, and but the republic is still there. But we, the people, are not operating it. It's the Vatican that's operating, and that's why I'm doing this, because I'm actually in the Court of Appeals. And I have an action that I'm bringing in the Court of Appeals, and I'm challenging. It's in the U.S. Court of Appeals for the Fifth Circuit right now, and I'm going to take it to the Supreme Court if necessary. The constitutionality of that minor estate, the 1871 corporation, and the bar. None of them are constitutional. That's all. The First Amendment says that. That Congress shall make no law respecting an establishment of religion. And that's what they've done. And then plus their bills of attainder. The minor estate is a bill of attainder. I mean, there's a whole bunch of reasons why it's unconstitutional. And so, I'm not going to get into a big argument with everybody right now. I am just going to, if you want to talk about it, you can talk about it after I'm done. And I'm going to wrap it up right now. And Lori, is there anything that you want to say? If you guys want to talk about this, you can talk about it after we're done. Is there anything you want to say, Lori, before I sign out?
Well, no, I don't think anybody was trying to create any havoc or anything. It was just it's a very difficult issue, and it's a fine line for some folks. So, that's the kind of things that we go through on We Are Law, and that's what makes it a great channel, is because we can discuss that openly. They are hard subjects, so everybody, it's nice that everybody shows respect and has patience for issue at hand. That's all I'll leave it.
And I don't fault everybody for.
Nope.
But I have my own ideas about it. You know, I mean, I agree it's a society. There's no doubt about it. But they have an oath of office, and they're supposed to be representing us. And but to a large degree, the Republic, the Obama and Bush used to get up there and say that our democracy. Well, it's a democracy because the Republic we're not using the Republic, and it's mob rule, and but if the people understood, then we could put a stop to it, and I think that's what Trump is trying to do, is put a stop to it, but it's warfare, okay, and so he is having to, all warfare is about deception, and so we'll see how it all works out with Trump, but I think that he's trying to, and so that's why I'm sending him a copy of this, because he needs to know about this kind of stuff, and I have remote viewers have said that Congress is going to adjourn for the last time, so. If it turns out that 1871 corporation is unconstitutional, then that's what's going to happen. They're going to have to adjourn because it's owned by the Vatican. You cannot unown it by the Vatican. I suppose they could seize it back. I don't know. I don't know if they can or not. But it's right now. It's owned by the Vatican. And Vatican owns D.C. It's all Roman law. All these courts are Roman law, trust law, and that's why there's no justice in these courts. And so that's all. It's all right there. It's all in this document. And so I put them in the position that they have to honor their oath of office, and that was the purpose of that document, is put them into estoppel. And so we'll see what happens. I have done this kind of stuff for a long time, and it works pretty good, actually. Anyways, the Word file is there, and anybody is welcome to take it and manipulate it and use it for themselves. But I'm about, let's see, we've been on YouTube now for 2 hours, so I'm about done.
May I real quick? I was wondering, in regards to what you were just speaking about, that you are about to file a constitutional question and about the Vatican and all that. When you, if you would, could you please discuss those soon, or possibly post those as well tonight? Because I have a huge civil rights, just like you said, mob action, and it's just treading on every single right known to us kings and queens. And I am in much great need to properly format, well, not format it, but present such an eloquent document such as your works. And thank you. I really appreciate your time and energy and all you put into this.
Mary's dealing with some CPS issues where that would really be helpful. So
okay, well, that's good to know. Yeah. I'll tell you what I have to start working on an appeal brief, and so maybe next week, and maybe if not next week, then the following week, we'll go through my appeal brief. How's that? And so I have an appeal brief I had to do for the Court of Appeals. I have to have it done and in by the middle of next month. So
July. That's foreclosure, correct?
Yeah. So I'm going to start working on that pretty quick, and so that'll probably be something that I'll want to go through once I get it to the point that I'm ready to submit it, or even after I submit it, we can go through the Word file. But
is that why you said you were wondering, or You stated that they were investigating you. Is that why? Is because of the foreclosure, or was there something else?
We held a common law court with the Republic of Texas, and so they're investigating something that went on with the common law court, but it's none of their concern.
Okay, I see. Thank you for clarifying. And then just, I was very happy to see that you wrote in I don't know if you put it in as an exhibit, but your fee schedule. I thought that was very interesting. We'll talk about that next week.
Well, this is a standard notice and demand. But I got to say, I've never ever collected anything, and I tend to wonder whether it's even relevant. I mean, they're a bunch of thieves and pirates, so we'll see.
You mentioned it before.
It's worked as a detriment. There's been times when I would send an invoice. I've got an invoice that we could go through sometime. It's pretty good.
Okay.
But
I'll put it on our list. We're making a list.
But so yeah, that's fine. Yeah, and I've got an invoice, and it's pretty good. It's one that I got, and I all that stuff I get from somebody else, but it's pretty good. But what's happened is I've used the invoice, and sometimes it works really, really good, and sometimes they just ignore it. And so the government,
like anything, though.
Yeah, the government entities tend to ignore it because how are you going to collect from the government entity? But private entities, I tell you, they just run away and hide. Anyways, okay, well, we're gonna end it.
Can I ask one more question before you go? You said something that they will call you a sovereign citizen, right?
Yeah.
I didn't hear you correctly. Are you saying that you are a sovereign citizen, or you should say nothing?
You know, there's all these people that say that there's no such thing as a sovereign citizen. And actually, the courts have said that there is, okay? And Congress says that there is. And so the word citizen is a fictitious entity. And so, you know, if you want to get into those arguments, then knock yourself out. See how far it gets you. My attitude is I go by what the courts say and what Congress says, and you read in that document, if you were watching, okay, and it really jerks my chain when people come in and start asking questions because they weren't watching, and they would know the answer, and so that's one of the things that really jerks my chain, that people come in and start asking questions about stuff that they don't even have a clue about because they weren't watching. Anyways.
I came in late, that's why I'm asking you, but I thank you for your response.
Yeah.
One time, a federal judge told me I am sovereign citizen, so I told the court, prove it. The sovereign citizen is a dangerous people, blah, blah, blah. And I explained, and she shut up. Federal judge, okay?
They have to. They use it as calling you a terrorist. And so I dump on them when they do that. I say, oh, that's right. Is that right? That's what Congress said, that they're sovereign citizens. So you're the terrorist. You're engaged in perjury of oath. You're engaged in treason and sedition. And so the fucking lawyers shut up so quick your head spins. And so I've been there, and I go ahead and let them hang themselves, because that's where I'm going to go with it. Is that first of all, in 1873, the Supreme Court said that everyone and everything not privileged is sovereign, and in 1940, Congress said that they were all sovereign, because we have a Republican form of government. So you're engaged in warfare, you're in treason to your oath to the Republic, and I start dumping on them, and they shut up really quick. And so that's why I say, you want to get into that argument, read this fucking document before you fucking start spouting off about something you don't know a fucking thing about. anyways,
in New York court too, actually, our attorney came and said, "Look, here's a FBI looking for sovereign citizen," and he posted a newspaper and on my court case, and I went after him, and I said, he is creating battery, temporary crime, and I said he has to be arrested, and then he disappeared from the mortgage case.
yeah, good. Yeah, good. Perfect. Yeah, exactly. Exactly. So you nailed him. And I would file a bar grievance against his ass. Yeah, they'll disappear. And they shut up real quick when you start bringing up stuff that, like about that 1873 court case and Congress saying that all the people are sovereign because we have a republic. And anyways, okay. Well, I appreciate everybody listening in, and the document, the saved document, is uploaded, so you can go ahead and I would, I use those documents all the time. I would use it as a template for your own, and you probably ought to thin it down. It doesn't need to be as long as it is. And I was thinking of some stuff that I could probably thin out of there, but I might be able to thin it down maybe a page or two, but I can't imagine much more than that, quite frankly, because I want all that stuff in there about the Vatican for Trump to see, because he's the guy that has the power to make Congress adjourn for the last time, and really that's what has to happen. Unless they can...
What about, you were speaking about the 13 original colonies. What about Northwest Ordinance, where Illinois, Wisconsin, Minnesota, Michigan, some parts of Minnesota, Indiana, or like 5 states, I believe. It was all about the slavery and 1820, the year 1820. I just looked this up. I'm not really good in history or this stuff. However, I know it's important to reacclimate myself with what I should have learned in the first place long ago. But however, how would that tie into this document? Because I know that Northwest Ordinance is one of the 4 organic documents that we need to have, like, established to know about. So if you can help me, thank you.
Absolutely. And the Northwest Ordinance is very powerful. It is one of the organic laws, and and I understand where you're coming from. There was 2 classes I hated in high school the most, was history and English, and now that's all I deal with. And so I understand where you're coming from, and so I that's why I get into these whole law dictionaries, and you start reading these whole law dictionaries and the stuff that's going on, and that's where I get the stuff that I put into this document. But so the Northwest Ordinance is really important. People, they just basically ignore that. But that defines the nature of federal jurisdiction in federal territory, and because we're under martial law, then the federal territory is everywhere, and so it's a valid argument, and so anyways, yeah.
We'll talk about that next week. We'll talk about that next week. You're going to touch the 3-hour mark here, and I'm going to start to feel.
I know, and I've got YouTube videos about it where we talk about the Northwest Ordinance. I would watch some of the more recent videos, live streams especially, that are on my videos. But they're probably not going to be on my website. They'll be just in YouTube. If you go to YouTube and the recent videos within the last 3 to 6 months, there's videos in there about the Northwest Ordinance for sure, and where we talk about the stuff that's in there. And so I would highly recommend that would be a good place to start. And there's that's a good place to start to get. If you send me an email, I'll send you a Word file that has the best. It's a friend of mine that got the original of the documents. He got certified copies of the Constitution, the Northwest Ordinance, the Declaration of Independence, and the
He has deep pockets, eh?
Articles of Confederation. And so if you send me an email, I'll send you the best Word file that's going to have the best text, because capitalization is everything. They had, when they wrote the Constitution, they had a style committee, and their sole purpose was to determine which words would be capitalized. So even capital in the Constitution, there's a lot of words that are capitalized in there, and there's a reason for it. And so in order to understand the Constitution, you got to understand the words that are capitalized and why they're capitalized. Anyways, I got to let you go. Thanks, everybody. And we'll see you next week. Same time, same place, same channel.
I'll count on it.
Thank you.
Good evening.
Thank you.